Thank you very much. One thing I tell people about opposing really stupid transportation projects, it's very much like singing at Liz Taylor's weddings. Doesn't pay much, but it's very steady work. Our first speaker today is William Pendley, and come on up. He was born and raised in Cheyenne, Wyoming. He received his BA and MA degrees in economics and political science from George Washington University in Washington, D.C. He was a captain in the United States Marine Corps, after which he received his JD from the University of Wyoming College of Law, where he was senior editor on Land and Water Law Review. Thank you. Okay.
In 1936, Melvin Brandt arrived in what is now Fox Park, Wyoming. He came with his wife, Lula. They had a paid-for Chevrolet full of gas and $2 between them. He borrowed a pair of boots, and he borrowed some tools, and he hiked up into the forest near the railroad and began to cut railroad ties. He cut down the trees, he'd shape them, he'd carve them, put them in the right length, and then put one of them on his shoulder and drag them down to the road, and then go back in the forest to get another one. He got a nickel a railroad tie. My goodness, in no time at all, he's making $1 a day. But he knew that that's not what he wanted to do for his life's work. After a couple of weeks, what he wanted to do was have a timber mill. And by, he and his friend that he met there, fellow Scandinavian, they built a timber mill. They built a timber mill there in what is now called Fox Park, Wyoming, 6 million tons board feet a year that it put through the mill. A very successful operation. He built a little community. He had to build a church. He built a country store. He built homes. And ultimately, he had a very successful operation. But one problem he had was his entire 83 acres of private activity and homes was situated on U.S. Forest Service land. And he knew that that was not a good idea. And so he went to the Forest Service and he said, what I'd like to do is buy that land from you. And the Forest Service says, well, we never sell stuff. Government only acquires stuff, never disposes of it. And so he said, well, the Forest Service said, but we'll trade for you. And he said, well, what do you covet? And they said, well, there's about 240 acres over there on Sheep Mountain we like, and over here south of town. And so he went out and bought that land, and he traded the Forest Service for it. And the Forest Service gave him a patent, and the patent said, here is your 83.3 acres of land encumbered only by a railroad right-of-way, because, of course, the railroad went right smack dab through the middle of the property. It serviced the mill, of course. And that was perfectly fine, and he felt pleased that he had solved that problem. Ultimately, he turned the timber mill over to his son, Marvin, and Marvin ran the mill, and then the 80s hit. And the recession hit, and bad times hit, and then the U.S. Forest Service decided to stop harvesting timber and decided to turn it over to the pine beetle. And the mill went under, and Marvin lost the mill. But he swore that he'd never lose the land that his dad gave him. He'd preserve that and keep that forever. And then in 2000, the railroad, because the mill was gone, the railroad went away. The railroad abandoned the right-of-way, took up the ties, took up the tracks, and that land, according to that patent that Marvin Brandt had, that railroad right-of-way went back to Marvin. In about 2005, the Forest Service came in and said, Mr. Brandt, we're going to build a bike trail here. We're going to turn that railroad right-of-way into a bicycle trail. And he said, are you nuts? We're at 9,000-foot elevation. We have snow here from late October until early June. And have you looked out at the trail lately? It's a forest. The trees are coming back. It's filled with spikes. Who's going to ride on that? And the Forest Service said, well, frankly, we've done a study, and we believe 200,000 people a year will use that trail. You've seen those studies. And then Marvin finally said, well, heck, it doesn't matter at all. I own the land anyway. Forest Service said, yeah, we know we do. but you got it, we want it, and we're going to take it to the Supreme Court of the United States to get it. And in June of 2006, the U.S. Forest Service, federal government, the U.S. Attorney for the state of Wyoming filed a lawsuit against Marvin Brandt, and Mountain States Legal Foundation represented Marvin, and we countersued and said, not only do you not own it, we own it, get away. Leave us alone. And the whole story is laid out in the copy of our newsletter that's in front of you today. But let me just simply summarize that over an 8-year period, we litigated against a U.S. attorney from the state of Wyoming, a Republican, a good friend of mine who happens to be governor of Wyoming today, in the George W. Bush administration, in the most Republican state in the country, Wyoming. And we litigated over a period of 8 years to get our land back and ultimately prevailed before the Supreme Court of the United States on the 10th of March. When the Supreme Court of the United States ruled, thank you. Yeah, that's what Marvin said and wiped away a tear. But we won when the Supreme Court ruled in an opinion by Chief Justice Roberts, and he said, gee, this is just fundamental law. This is property law. Simply when you have an easement, when you have a railroad easement and the purpose of the easement goes away, it reverts to what? It reverts to the underlying property owner. That's just simply law. It's been law all the way back into England, into the common law. In fact, Justice Breyer, who loves bicycle trails, you know, Justice Breyer, the liberal, loves bicycle trails. In fact, he's tried to kill himself several times on bike trails. And true story. And he said, I love bike trails, but any lawyer worth his salt understands that when this railroad went away, Marvin Brandt got the land. Justice Kagan, another Obama appointee, or an Obama appointee, a former Solicitor General of the United States, she said, why anyone that doesn't understand that Mr. Brandt got the whole ball of wax when this railroad went away is beyond me. And sure enough, that's why we won 8-1. Now, you're probably saying, who's the one? And the one was the wise, self-described wise Latina, Sotomayor. Saida Sotomayor filed a lengthy dissent that Linda Greenhouse, who always gets things wrong, who writes for the New York Times, found with much favor. But Sotomayor said, essentially, to paraphrase, trails are good. People like trails. And if Mr. Brandt wins, the federal government will have to pay hundreds of millions of dollars to buy these trails from private people, and that's bad. If you don't think that's her opinion, take a look. It summarizes her opinion. Now, people describe this as a rails-to-trail case. It's not. It's really a case about the perfidy of the federal government. The fact that the federal government gave our client a patent that was clear on his face, had been clear for hundreds of years what it meant, and then reneged and said, no, maybe we meant that when we did it. Maybe we meant that in 1942 when a case like this appeared before the Supreme Court of the United States, but it doesn't mean that anymore because we want it, you got it, we're going to get it. Now, having established my nonpartisan bona fides by suing the George W. Bush administration and its U.S. attorney, my good friend Matt Mead, and the state of Wyoming, because Wyoming supported this project, it'll be no surprise to you that the Wyoming Department of Transportation thought this was a great idea to seize my client's land and use it for a trail that nobody will use. And oh, by the way, over the years that this has been the case, my client has seen no more than 50 people on that trail. Mostly he sees horseback riders, ATV vehicles, and motorcycles, all of which are illegal on the trail, and only maybe 50 bicyclists. Well, having established my nonpartisan bona fides, let me say that we are living today in the most lawless administration in the history of the Republic. In May of 2013, Congressman Tom Cotton gave a speech in Washington, D.C., in which he said the Obama administration is so much as unconstitutional in its actions as anti-constitutional. That is to say, the president has a natural antipathy toward the Constitution, the rule of law, and the way our system has operated since the Founding Fathers created it. In May of 2014, Senator Ted Cruz commented that he had found 76 specific instances in which President Obama had violated his constitutional duties and violated his oath of office. And then in December of 2013, 4 professors, law school professors, were brought before the House Judiciary Committee, 2 conservatives, 2 liberals. I don't know how they found the conservatives. I don't know what law school they were from. But one of the liberals on the panel is a man by the name of Jonathan Turley. You've seen him on TV. He's a self-described progressive, liberal, Obama supporter. But even Professor Turley said we have reached a tipping point in our constitutional republic because of the abuse of power by the President of the United States. He has made absolute shambles of our system when you go from executive orders to czars, to unconstitutional recess appointments, from not enforcing the laws that are on the books, to making up laws out of whole cloth, to stepping in front of the White House press office on an almost daily basis and rewriting laws and federal regulations without benefit of adherence to the Administrative Procedures Act. He's made absolute shambles of our Constitution, balance of powers, this dual sovereignty, and the liberties it's meant to protect. And bear in mind that the way it was all structured was not, for example, the 10th Amendment was not written, as Justice Kennedy has pointed out, written to protect states. It was written to protect the liberties of the American people. That's why it was written the way that it was. It's Orwellian, it's Nixonian, it's Saul Alinsky-ish, and it's greatly troubling. And I could go on at great length, but you've been watching the news and you know what he's been up to. Now the point of this is simply to say that this lawlessness has an impact. This lawlessness has an impact in Washington, D.C., and I maintain that this lawlessness goes from the White House, from the Oval Office, all the way down to the lowest bureaucrat in the field. I carry no brief whatsoever for Cliven Bundy, a cowboy out in Nevada who for 20 years refused to pay his grazing fees. I do not know how you get away with that. I do not know how you don't pay your fees for 20 years, but the overreaction by the BLM by sending out SWAT teams and assassins and snipers to prey upon him was positively outrageous. Back in April of 2009, the Department of Homeland Security issued a report on domestic terrorism, the threats to the Republic, and concluded that people like the people in this room, me and you, are the greatest threat to liberty and the greatest source of domestic terrorism in the country. If you don't believe me, Google for it. April 2009, I've written on it. Fast forward to the Cliven Bundy situation, and what did Harry Reid say right after the Cliven Bundy situation? Cliven Bundy is a domestic terrorist. Just like is written about in that 2009 report. And in just 2 weeks ago, the FBI came out with a report at the height of the ISIS crisis, the JV team, as Obama calls them, and not one word from the FBI on ISIS, but many words about you and me and people like us. And this lawlessness has an impact, and the impact is simply that people at the state level and the county level and the city level look at Obama and say, well, why can't we do that too? Why do we have to obey the law? Why can't we do what we want to do? And if you don't like it, well, sue us. And so that's what Mountain States Legal Foundation does. And so we sued Governor Cuomo for telling the people in upstate New York that they can't drill for oil on their property. They can't drill for gas on their property. The 13 most productive gas wells in the state of Pennsylvania in the Marcellus Shale are in Susquehanna County. And across the border in Broome County, where my client lives, it's the same situation. But my client, John Kark, who's been on the 6 generations on the land, a farmer, can't drill on his property because of Governor Cuomo. And so we sued Governor Cuomo. Our client cannot pay his taxes. Our client cannot pay his mortgage. And And so today, instead of being at home with his 4 kids and his 6 grandkids and run his farm and run his cattle and run his trucking company, he's in Oklahoma living out of a camper, working in the oil patch because of Governor Cuomo and Neil Young and Willie Nelson and Yoko Ono, all of whom oppose his drilling on his property. I used to think the worst thing Yoko Ono ever did was destroy the Beatles. I'm no Beatles fan. Marty Robbins, Roy Orbison, Johnny Cash, those are my folk. But I think the worst thing Yoko Ono's ever did is condemn the people of upstate New York to poverty. And we've also sued down in Mora County. I like to call it Moron County. Down in New Mexico, Moron County has fallen under the sway of a left-wing group out of Pennsylvania, supported by Teresa Heinz Kerry, big surprise, that is going around the country telling counties, bar oil and gas development, bar hydraulic fracturing, and declare corporate entities to be persona non grata in their county. Now that sounds really crazy, doesn't it? It really sounds foolish and stupid. And it is. It's totally unconstitutional, but 150 municipalities have adopted that ordinance, including Mora County, and we have sued Mora County. And finally, as you probably know, if you're in Colorado, we sued Aspen, Colorado, because it adopted a bag tax, a 20-cent tax, which clearly violates the Tabor Amendment in our Constitution that says we can't have taxes imposed, we can't have indebtedness, we can't have the government acquiring more responsibilities without us voting on it, and so we have sued. There are several statutes that cause great problems for us, and I maintain as a Westerner, as someone who defends the property rights and a person who defends ranchers and people in the rural West, that an effort by the environmental extremists, and that's a Reagan term, is to drive people off the land and to drive us all into the cities where we can be controlled by the folks that you have battled and you have dealt with. And they're using three statutes to do it. One is the National Environmental Policy Act, or NEPA. The second is the Endangered Species Act, what the environmental extremists call the pit bull of environmental laws. And the third one is, of course, the Clean Water Act. Let me speak briefly about the Endangered Species Act. It was written back in the 70s. It was supposed to protect 100 species. Today we got about 2,000 on it, and we're going north. We're gone from protecting the warm and fuzzies to protecting the cold and slimies. Second, it was supposed to apply only to federal land. Today it applies to private property, coast to coast, border to border, which leads us here in the West to say, what? Shoot, shovel, and shut up. If you encounter one of those critters on your property, and that's, by the way, not legal advice. And the third promise was that if any property was ever taken for endangered species, a property owner would be compensated, just compensation for the taking of private property. That has never happened. You're thinking 3? I'm thinking 5. And let me mention the Clean Water Act. The Clean Water Act, when it was written, it was 88 pages long. It had 5 words in it that said, waters of the United States. That's the jurisdictional term that allows bureaucrats to come onto your property and shut you down. Well, what is waters of the United States? Well, the Obama administration recently published regulations to define that term. Remember, the statute originally was 88 pages long. They published 270 pages of regulations to define those 5 words, including appendices. They had appendices. One appendix was, it's alone 300 pages long. Well, and now I ask the question, since I believe that 2014 looks so much like 1970s and 1980s, my question is, what would Ronald Reagan do? And this is my book that I just wrote last year, July, Sagebrush Rebel, Reagan's Battle Against Environmental Extremists and Why It Matters Today. And I want to give you in closing just 3 takeaways from my book It's available in the back, as is tape, if you want to listen to it. It's got last 9 tapes, and then at the end there's an MP3. I don't know what you do with that. Ask your kids, I guess. But let me give you 3 takeaways on environmental extremists. Number 1, they don't care about people. There was a day when the environmental movement, whether it was conservation or preservation, cared about people. People's need for conservation, for food, fiber, and water, or people's need for preservation to be able to go out and enjoy God's creation, God's great creation, to worship the Creator, not His creation, and to draw spiritual and psychological and emotional restoration from that. That was in the old day, and Reagan knew about that, and Reagan believed that. Environmental extremists in the 70s became haters of people, declared people to be cancers on the planet, and wished for their demise and destruction. The second takeaway is the environmental movement, the environmental extremists, is an arm of the Democratic Party. Now, there's absolutely nothing wrong with that. They can be partisan all they want, but don't tell me that you're a nonpartisan organization entities. They went out and endorsed Jimmy Carter in October of 1980, and then stepped out on the White House lawn and excoriated Ronald Reagan, and they have been doing it ever since. And finally, environmental extremists are not Greens, they're Reds. Now, I used to quote my friend Stephen Moore, who wrote about this in the Wall Street Journal. No longer. Because in July of this year, the environmental extremist groups, 130 of them, issued a proclamation saying, "We call for the end of capitalism." Okay, thank you so much. Case made. So when we battle these people, let's bear all of this in mind. Let me finally conclude by commenting on Reagan's instruction to my boss when I was at the Department of Interior back in the 1980s, and that was to Jim Watt. Because times were getting tough, and Jim was getting ready to back down on some issues, went in to see the president, told him he was going to back down on some of the president's initiatives, and the president said, "Jim, if you don't do it, who's going to? And if we don't do it now, when in the world are we going to do it?" Those words probably sound familiar to you, and they should, because he said that in the second inaugural address. He said, "As I tell my cabinet and my staff, if not us, who? If not now, when?" And that's our commission as we fight these battles. And we have incredible battles to face and fight, as you all know, from the wars you bring in here today and tomorrow. But we must be of good spirit as Reagan was, and fight back, because after all, if not us, who? If not now, when? Thank you very much. Thank you.